obviously not surprised that she got the denial because this is typically what occurs. And I explained to her, listen, one of the most important things is to make appointments with all of your treating doctors. And you have to make sure that your doctors understand that the definition of disability has changed. So oftentimes treating doctors, they don't know, they're not in the business of knowing what a disability policy says or what claim forms are supposed to say. So oftentimes they're still documenting, can't lift, 50 pounds, can't do physical job, when after the change of definition, it's can you sit at a desk for 40 hours a week and do a sedentary job such as reviewing medical records or being a nurse manager and something that doesn't involve any kind of physical activities. So that's what switches, and oftentimes if the doctors aren't on board, then what happens is you can't get the claim approved because the doctors are still on the same page of she can't do the physical job. So.
Hi, I'm attorney Gregory Dell, joined by attorneys Rachel Alters and Cesar Gavidia. And we always get together every week. We're constantly talking about our cases, but through our YouTube channel, we go and we have the opportunity to talk about a variety of topics. Today, we're going to talk about, Rachel, one of your resolved cases, which was an appeal that you recently won on a long-term disability denial against the Standard Insurance Company. So what you'll do is you'll go through the background of your case. We'll talk about what you did. We'll talk about some tips for people that they could benefit from. And Cesar and I will jump in and have a conversation about this so a lot of people can learn from these videos to help protect their disability benefits. So start with giving us the background of your case.
Sure. I represent a registered nurse who had stopped working due to many back issues. She had knee surgeries, multiple back surgeries. She had a lot of arthritis, a lot of things, and her job was very physical. So she was lifting patients who could be, up to 200 pounds on their feet all day long. So she was approved by the Standard. They paid her 24 months under the own occupation definition. And then after the own occupation definition expired and it turned into the any occupation standard, they denied her. So she came to us to do an appeal for her.
Okay, Cesar, how often in your claims against the Standard do you see a denial when someone's transitioning from the own occupation to the any occupation? And when you answer this question, just briefly explain the difference between ONOC and any OC.
Sure, it's actually very common. And the reason it's so common is because you're shifting from a specific definition of disability related to your own occupation, material duties of what it is your particular occupation includes, to now going to in order to remain eligible for benefits, being unable to perform the substantial material duties of any gainful occupation for which you're qualified by your education, training, and experience. So, obviously this transitionary period is going to trigger a review by the insurance company, not just an occupational review, but probably a medical review of your entire medical records, history. They're going to be assigning this to somebody either internally or externally that has medical expertise or a medical background to review and provide them with feedback and an opinion about your restrictions and limitations.
And Rachel, in your case, the Standard usually does more detailed reviews than most other disability insurance companies. And in this one in particular, did they use, and they have an extensive in-house team at Standard. And by that I mean that they have their own physicians that they either have as employees or they have contractual relationships with them in a variety of medical specialties that they'll go to them and they'll say, hey, here's this particular claimant, here's what's going on with them, here's their medical records, do they have restrictions and limitations? So I'm assuming in your case they went to their in-house team and based upon the review of their in-house team, they denied benefits.
Yes, correct.
Okay. So some people might be saying, are they allowed to do this? Can they use, the same company as reviewing my claim is using their hired doctors to review a claim. How am I getting a full and fair review? Is that allowed under the law?
It is allowed. Unfortunately, it is allowed, and of course it's biased because these are people that work for the Standard, are paid by the Standard, so of course they're inclined to give an opinion that's favorable for the Standard. So it doesn't seem like it would be fair. However, it is fair, and even in a court of law, a judge will look at this and they won't throw it out because these were experts that were working for the Standard. So unfortunately it is, and then, but we deal with this often and we know how to refute these peer reviews.
So Caesar and Rachel, a lot of
Yeah.
claimants call and they go, I can't believe they did this. They denied my claim. They just used their own doctors. Why do their doctors know more than my doctors? They didn't even see me. They didn't even call my doctor. Like, what was missing here? And so that's just a general statement I'm making. That happens all the time. We see it with every single denial. But based upon what you had, Rachel, you had basically Standard's own doctors telling them, look, this person's not disabled. What did you do for this claimant to get the benefits reversed?
So when she called me, I obviously am not surprised that she got the denial because this is typically what occurs. And I explained to her, listen, one of the most important things is to make appointments with all of your treating doctors. And you have to make sure that your doctors understand that the definition of disability has changed. So oftentimes treating doctors, they don't know, they're not in the business of knowing what a disability policy says or what claim forms are supposed to say. So oftentimes they're still documenting, can't lift 50 pounds, can't do physical job, when after the change of definition, it's can you sit at a desk for 40 hours a week and do a sedentary job such as reviewing medical records or being a nurse manager and something that doesn't involve any kind of physical activity. So that's what switches, and oftentimes if the doctors aren't on board, then what happens is you can't get the claim approved because the doctors are still on the same page of she can't do the physical job. So I tell my clients all the time, go have an appointment with your doctors, explain to them you've gotten denied, and now we need to make sure we're documenting that I have issues with sitting for extended periods of time, that I can't lift greater than 10 pounds, whatever the sedentary definition is. It has to be in their medical records. It can't just be them starting to write, fill out a claim form saying, oh, now we've changed our mind that she can't do her job as a registered nurse, which is a physical job, and then all of a sudden today, she can't do a sedentary job. So I tell them it's very important to have them documenting this all along if possible, but they don't usually come to me until after the 24-month
So you sent
denial.
your
Yeah,
client back to the doctors and got
Yes.
better medical
sure.
documentation, but there's more than that you did for this
Oh,
particular
yeah.
appeal. So
A
tell us
lot
what
more.
you did.
We also had her participate in a functional capacity evaluation, which is, it's done by a physical therapist, and it's a 3-hour evaluation that tests how long she can sit, stand, push, pull, lift, climb, all the kind of things that could be required of her. They review the medical records as well, and then they write a very detailed report of what she's capable of doing. And obviously, if this comes back favorable, we're submitting this with the appeal and with an opinion that, hey, we looked at the medical records, we tested her in all these capacities, and it's our opinion, a professional opinion, that she's not able to do any kind of sedentary work for extended periods of time with any kind of reasonable continuity. So that's something we did in this case, and it was very supportive, and we submitted that. We also worked with her doctors, and we create something called attending physician statements, where we will tailor them, custom tailored,
Yes.
like a suit, to show that she's not able to do these specific things that are tailored towards her particular disabling conditions. So she had multiple back surgeries. She also has knee issues. On top of it, she had fibromyalgia. So she had a lot of physical things going on, which she was in pain all day long, from the time she woke up to the time she went to bed. So we would tailor these attending physician statements and have her doctors fill them out so as to agree with, coincide with the medical records that they're already writing. They'll fill out the attending physician statement, and then we also send them the functional capacity evaluation, the report, so that they can also see that this has been done, and they will also comment in the attending physician statement about that they agree with the findings. And then we submit all of that. We also hired a vocational expert because Standard had their vocational review done as well. So they have a vocational expert saying it's their opinion that based on the education, background, training, experience of my client, that she can do these 4 jobs. And what they do is they'll list 4 jobs. It's a nurse case manager, review of medical records, whatever they may be, she can earn up to this much money. And we found these jobs, within 5 miles of her home. Therefore, we agree that she can go back to work. So we had to hire somebody who would review that, review her educational background, her training, her records, and all of that, and give a report of this obviously opposite opinion that they disagree with their vocational expert that she's not capable of doing these things. So we put all that together in a package. Our appeals are very lengthy, as you know, and we prevailed. They overturned their decision after we gave them a lot of objective proof of why our client is still disabled and unable to do what they claim she can do.
It sounds like
Yeah.
you did a tremendous amount, and it's always
Yeah.
crazy to think that they tell claimants, just go ahead and submit your appeal and we'll
Oh,
have
right.
someone else review it, because the laws require a different person who denied the claim must review the claim on appeal, which is good because now you're getting a different opportunity to look at the claim.
Sure.
And different doctors. Nobody who was involved before can now look at it on appeal, which is great, and you got it in there and you got it reversed.
Yes.
But Caesar, as someone who's litigated thousands of disability insurance denials, which is the stage that happens after an appeal, in this case our client won, phenomenal. She will never, she's not even gonna have to deal with litigation. But talk for a minute to help people understand, why is it so important to do everything that Rachel did? Because someone's watching this is going like, that's a lot. Like, she did a lot. But why is it so important to do that during the appeal? And you speaking from your view as a litigator, because people have no idea.
Yeah, and unfortunately, the insurance company, in this case with Standard, but the same is true for all of them. They will never explain to you how critical and how important this appeal review process is. And the reason it's so important is because your entire case, from going from the claim process into litigation, going into federal court, where a federal court judge, a U.S. District Court judge, who's appointed by the President of the United States to serve in that position for lifetime, is going to be charged with reviewing your case if it ends up before them, determining if the insurance company made the correct decision and if you're indeed disabled. And the only body of evidence that federal judge can consider and review is what's been provided in this administrative review appeal process and through the claim. Once that door closes, once the final appeal is decided and that final denial letter is received by the insured, that's it. There's no ability to now provide additional evidence. You can't go back and say, I really could have benefited from a vocational analysis. Let me submit it now. Let me send it to Harvard now, or let me present it before the federal judge now. You don't have that opportunity.
So to break it down and ask you a simple question, if Rachel's client had done her own appeal and didn't put in any of the stuff that Rachel mentioned, and the client had called and said, Rachel, I want you to file my lawsuit, could Rachel have introduced all of that additional evidence that she was able to obtain for the appeal?
No, unfortunately, she would not have been able to do that.
Is there any way around that?
The only way around that.
And this is not a trick question.
No, I know. The only way around that is in the very rare circumstance that now your lawyers have convinced that federal judge to remand that case back to the insurance company to now reopen the appeal review process because of some legal loophole or some violation of your full and fair review rights. Again, this is like legal gymnastics that is done in litigation, but it's going to be very, very hard and challenging to do. But only under that very, very rare exception would that be allowed. But absent that, in 90% plus cases, that wouldn't be.
Yeah, so the bottom line takeaway is that you have to do an amazing appeal.
Right.
Every single piece of evidence, anything you ever want to say, anything you ever know about your medical condition, about your limitations, anyone who has anything whatsoever to say about your disability and why you're disabled must be in that appeal. If it's not, it's not going to come in now.
Right.
That doesn't mean the person who's watching this video or considering working with us or needs help and is going to call us and we're going to say, sorry, we can't win your lawsuit because you didn't do A, B, C, D, and E. No, but are you at a disadvantage? Yes, depending upon what your appeal is. And you probably didn't do everything that you could have for your appeal because you and Rachel have been doing this for more than 20 years. They've been denied for the first time. How are they possibly supposed to know what should go in there when Standard just says, well, go ahead and send us your updated medical records and tell us, I don't even know, tell us why we were wrong? I mean, it doesn't work like that.
And I've had that question. Oh, how am I supposed to know? I'm just an average. I'm just a person. I'm not a lawyer. I'm not I'm not an insurance expert. And there's unfortunately lack of knowledge of the law or lack of knowledge of something is not a defense. You're assumed to know that this is how this is going to operate. They notify you that you have appeal rights, that you can provide them with additional supportive evidence, and that's all the insurance company needs to do. They don't need to hand walk you through the whole process.
No, they're actually hoping that you don't hire
Right.
a lawyer. They want you to just write a paragraph saying, I disagree with the fact that you denied my claim. And they don't even know they're supposed to go back to their doctors to get updated doctor opinions or records. Like the insurance companies don't give them those instructions. They know that if they hire a lawyer, then you know, we're going to fight them. But they're hoping that they don't.
And in the worst case scenario, they don't do an appeal within the 180 days, which is essential. That is like non-flexible,
Right.
non-negotiable.
No.
And then they call, and one of the first things we say on anyone who calls us is, did you do an appeal?
Yeah.
You know, of course, after they've received a final denial. If they say no and the 180 days have ran, there's nothing that can be done.
No.
Except for one maybe scenario if they didn't tell you when you had to appeal by, which is very rare now, especially with someone like Standard. They probably aren't going to screw that up. But the bottom line is you have 180 days to do that appeal.
Right.
And if you don't comply, you're dead to rights with that. So congratulations on winning this appeal. It was obviously very difficult, but somewhat typical in the change of definition. I'm sure your client's very happy, and I know you'll continue to represent her because just because you win these cases, you still have to do everything to prove your eligibility month after month after month. So if you're someone out there who has a claim with the Standard, whether it's short-term or long-term disability, feel free to reach out to Rachel or Caesar or myself. No matter where you live in the country, we're available to assist you, and we'll always provide you with a free consultation.